Ladies and gentlemen, Derek Chauvin is pulling an Amber Geiger. I guess he's now comfortable in his new federal prison, over there in Club Fed. And now he's taking on that same attitude. Why do I have to even be here? Why should I be in jail? And he is now working towards vacating his present conviction for a whole new trial. So he's now turned into Amber Geiger. So, a lawyer for Minnesota says Derek Chauvin requests to vacate his conviction in the George Floyd murder, says the quiet part out loud. Yeah, he doesn't want to serve any time for it. Lawyers for the state of Minnesota said Wednesday that ex police officer Derek Chauvin's bid to vacate his conviction for the murder of George Floyd says the quiet part out loud and argues that the police officers cannot ever be convicted of assault. Did you hear this? Did you hear this crap? And judging how we get treated out here, I think this is what they really believe. Police can never ever be convicted of assault. Wow, y'all really got the place rigged up for real. But the law authorizes officers only to use reasonable force, according to a brief filed with the Minnesota Court of Appeals. When officers use unreasonable force, the law holds them responsible. That's not true. We have gotten countless police officers that have murdered unjustly unarmed black people, and they have never been held responsible. You got citizens like Carolyn Bryan that have never been held responsible. So that's not true. Though you might say that in words, but as far as applying the action, that's a whole different thing. The filing submitted by lawyers from the Office of Attorney General Keith Ellison, as well as private practice attorneys arguing on the behalf of the state, said that Chauvin's brief raises an industrial kitchen sink worth of arguments, all of which are meritless, and is riddled with factual errors, half truths, and inaccuracies, large and small. This is according to Minnesota lawyers. Can't respond to each, but they wrote, but asked the judge to consider this. Chauvin still maintains that putting your knee on the back of a suspect cannot kill someone. Well, if you didn't put your knee on his back, you put your knee on his neck, and it did kill him. That's why he's not walking around today. Oh my goodness, he put that in there? All right. Mm-mm-mm. All right, so he's already starting out lying already because you didn't put your knee in this man's back. You put it on his neck. And he was telling you at the time he could not breathe. The lawyer said that Chauvin's brief contains multiple misrepresentations. And my But see, you allow officers like Derek Chauvin and Amber Geiger to do these things. And when you murder someone, you shouldn't be allowed to do all of this. And this is why so many people said Derek Chauvin should have gotten life behind bars. Giving him 22 and a half years, give him the opportunity to do just what you're seeing right now. The filing submitted by lawyers from the Office of the Attorney General, Keith Ellison, as well as private practice. So I read that part. I'm going to go down a little more. Notwithstanding the fact that Chauvin has also placed his knee on Floyd's neck, Chauvin's assertion, and others like it, is a flat out untruth. And this is what they're saying. As copyist evidence prove that, and he had a trial by jury, and Derek Chauvin was known for being rough with people, especially people in the black community. And he was prone to choking and a person while they were being restrained. Because y'all remember, a 14-year-old came up as he was doing the same thing to him. He didn't die, but there are others. It was another black man that came up and said Derek Chauvin did the same thing to him during an arrest. And you know how it is. They know which one of these cops are rotten like that. But in America, that cop is still allowed to be protected. See, all of that should have came up during Derek Chauvin's trial, but they would not allow it. But it should have all been spoken about in that courtroom. Okay, so I know they have filed separate charges on the behalf of the 14-year-old, he's probably a grown man now, but that has not come up yet. So, Derek Chauvin, they're saying, was specifically trained to avoid doing exactly what he did. That is how George Floyd died. The truth matters. The brief, which calls for the appellate court to affirm Chauvin's conviction, was filed in response to an open brief filed April 25th from Chauvin's attorney, and his attorney's name is William F. Mormon. So the brief argues that Chauvin is a police officer statutorily authorized to commit assaults to effect an arrest under Minnesota state law. Now, do y'all have these? We should be looking. So y'all have these laws in every state that an officer can commit assaults while arresting someone, and it's allowed under state law? Sometimes it's good that they file these briefs because, it allows you to find out new things that these folks will hide in plain sight. And believe me, they're hiding plenty. Because police officers are duty bound to assault suspects resisting arrest. That's why they heavily use resisting arrest, because now you're seeing it now justifies them assaulting you, because resisting arrest is something they heavily use on the black community. Now you see why they got laws in place saying that cops can assault you if they said or they claim you're resisting arrest, but they'll say you're resisting arrest and you look at the video and you don't see no resisting. Now you see why they heavily use that, because then it allows them to lay hands on you. Now let Derek Chauvin keep filing these documents because it's revealing a lot. Now, y'all know as soon as you hear resisting arrest, they got statutes in place that say officers can then lay hands on you. All right, so let's move on because I trust me, they don't just have this in Minnesota, they got this nationwide. That's why nationwide, you're already, it's like they go into autopilot saying resisting arrest. Now you know. No, Derek, keep filing these BS papers to the appellate court because I want to see what you're going to reveal. You revealed something huge. Okay. So it all, let me just go back and read that because police officers are duly bound to assault suspects resisting arrest. Minnesota's assault statute becomes a strict liability statute for a police officer because the officer always intends to physically touch the suspect. And this is what it says in this appellate document that was filed. Mm, 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 mm. Wednesday reply brief said Chauvin ignores the key limitation on his authorized use of force defense. The law authorized only reasonable touches, but y'all really authorize anything because I have seen these cops grabbing on people that just got out of their car and just stood there. And the officer is just upset because 9 times out of 10, it is a black driver that was questioning the legitimacy of the traffic stop. And everybody got the right to question that, especially if you were driving along and you weren't doing nothing wrong. And this officer has clearly spotted you and pulled you over because you're black. They don't like being questioned. So, in their mind, you questioning them, you're overstepping your authority, and they got the right to lay hands on you. And no, the law should not be used that way, but it is used that way. It's just like when you see cops encounter a black man that's walking alone down the street, and all of a sudden, we saw that with Elijah McClain. He was just walking home from the convenience store, and they killed him. So you can't say they are reasonably using these, I guess, these policies that you have in place saying they can lay hands on people. And in Chauvin's case, it was never reasonable. Never. And before Chauvin restrained him, did anybody have sense enough to get the $20 bill? We don't even know if these cops retrieved the $20 bill. That is another thing that has never come up. We heard about the counterfeit $20 bill, but out of all those officers, we haven't heard that one single officer actually took that $20 bill as evidence. If there's a counterfeit bill and you called the police over that, shouldn't someone have taken that $20 bill into evidence? You haven't heard about none of these officers doing that. The brief is signed by Assistant Attorney General Matthew Frank, whose team include former acting U.S. Solicitor Neil Katyal and his fellow partner Hogan Lovells. So, ladies and gentlemen, this is just unbelievable. So Chauvin, we know, is serving 22 and a half years. He was in state prison, and I believe he really should still be there. He should still be in state prison. He also pleaded guilty in federally violating Floyd's civil rights, and he was sentenced to 21 years. Three of the other officers were charged in state and federal court. So King, he was sentenced in July to 3 years in federal prison for violating George Floyd's civil rights. And Tao was sentenced to 42 months. Lane has been sentenced for 2 years behind bars. And to me, these three officers, because they did not act or do anything to stop Derek Chauvin, they should have got way more heavier sentences than 3 years, 2 years, and 42 months. I'm sorry, that's how I feel. They had ample time to get Derek Chauvin off of George Floyd. All three still have pending charges in state court for aiding and abetting, second degree murder, and second degree manslaughter. Mm, mm, mm. So, ladies and gentlemen, this should all be kicked out of court. Derek Chauvin is full of crap, just like Amber Geiger, but we will see how the court will respond. They should throw this crap out. If anything, they should have the ability to give us behind more years. Please tell me what you think about this story. Please leave your comment and subscribe. Don't forget to hit on the notification bell, and I'll see you on the next video. Peace, family.